the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome to the Fair Housing Insiders Case Files, where we break down real fair housing cases to help property management professionals stay ahead of legal risks and stay committed to compliance. I'm your host, Jonathan Saar. Today, we are diving into a federal case with major implications for municipalities, housing authorities, and property managers alike. It's United States versus Rockland County and Village of Spring Valley, a case that reminds us what happens when fair housing obligations aren't just ignored, but actively stalled. So as always, I'm joined by attorney Leslie Tucker to unpack the details. Leslie, good to have you here again today.
Yeah, thanks, Jonathan. Good to be here.
So let's take it from the top. What triggered this lawsuit?
Jonathan, this all started with a pair of administrative HUD complaints back in 2013, a long time ago. The complaints alleged that a private developer used HUD grant money to build condos, 62 units specifically. But those units ended up being designed for and marketed specifically to white Hasidic Jewish home buyers. And, in that process, they allegedly excluded Black applicants and really didn't market to the broader community. So the investigation of those complaints found that although only 14% of that marketing area was white, an estimated 91% of the property demographic was white. So even though the developer was allegedly responsible for those decisions, HUD found that both the county and the Village of Spring Valley, they were recipients of the federal funds and that they had reason to know about that discrimination and didn't do anything.
Okay. Yeah, that is a long time ago. So what happened to those 2013 HUD complaints?
HUD ended up entering into a VCA, a Voluntary Compliance Agreement, with the county and the village in 2018. That's how long that process took to investigate and get into settlement. The goal of that VCA was to kind of make things generally right by requiring those two entities to build 62 new affordable housing units over the following 7 years. And of course, the VCA laid out different strict affordability guidelines for those new 62 units, that they be affirmatively marketed and made sure that they were located in areas that would kind of diversify the housing opportunities there.
Okay. Did they follow through?
Well, HUD says no. HUD says that he did not follow through. By the first 3-year deadline of that 7 total, they were supposed to complete at least 25. However, during that time period, they only finished 4 that met the specifics that were included in the VCA. So in 2021, which was, a couple years later, HUD did approve an extension. Obviously, we were going through COVID at that time. So they approved an extension. They reduced the total unit obligation from 62 down to 58. And then they got some new deadlines. And HUD said, all right, we'll give you until March 2023 to complete 18 compliant units. But even though there was sort of these changes with the VCA, HUD alleged that the county and the village didn't complete even a single one.
Okay. So is the Department of Justice now stepping in? Is that what's happening?
Right. Yeah, exactly. So at the beginning of this year, January 2025, the Department of Justice filed a federal lawsuit basically saying that you didn't comply county and village, you didn't comply with your obligations under the VCA. And they are allowed to do that. VCAs are a contract. So if there's an allegation that one of the parties didn't comply with their obligations, it can go back to court. So the government is seeking civil penalties for violations of the Fair Housing Act. And, kind of in response, the county is saying that, we didn't meet the requirements, but it was due to circumstances completely outside of our control, and kind of alleged that HUD failed to take those into consideration in good faith. And this case is still active. It's still going on.
Okay. Very interesting case. So for our audience, and what's the lesson for property management professionals?
I think a good takeaway is that this is kind of about long-term accountability. This case really started a long time ago. The alleged discrimination was initially investigated over a decade ago. And the settlement was signed in 2018. And here we are in 2025, and the government is saying, all right, and enough is enough. We're kind of done waiting. So if you're a property manager thinking that fair housing enforcement is quiet or has gone dormant, this kind of shows that that's really not true. We have, here in this administration in 2025, they are enforcing not only current fair housing issues, but ones that were on the books for a long time. So even when HUD kind of delays enforcement or federal oversight slows down, be aware that your responsibility doesn't. So private lawsuits, advocacy groups, state enforcement agencies are still very much active and still aggressive. So the Fair Housing Act, as many of you know, has a 2-year statute of limitations. But once an administrative complaint is filed, this time period can be very much drawn out. Right. So don't get complacent just because you haven't heard anything for a while.
Right. Yeah. Excellent points, Leslie. Yeah. Thank you. Because it might be tempting to cut back on training, audits when enforcement seems low, right?
Yeah. I mean, I think that would be a costly mistake. The people who allege discrimination haven't disappeared, right? They are still living in your properties, and neither has their legal right to fair housing enforcement. So I think this case just proves that this government, regardless of what you might believe about it, is still willing to step in even years after the fact.
Yeah. Okay. So what would you advise property managers to do right now?
I think you have to be serious about your training. Keep it up, maybe even double down. This is still happening. Revisit your marketing policies, right? The marketing was a huge part of this case. And it's still part of a lot of cases that I hear about, to make sure that you are still casting a wide net when you are marketing your properties. And third, if your company has a conciliation agreement or a VCA, don't let those obligations slip through the cracks just because you feel like no one's going to notice. Stay vigilant about making sure you are checking the boxes on those obligations.
Yeah. Good reminders. Thank you so much, Leslie, for walking us through this case. It's a lot to think about with something that is dated back so many years ago and is still an open case for today. So appreciate you explaining that and providing us some good feedback on what we can do now. For our listeners, thank you for being here. To summarize, if you think fair housing enforcement is something only government agencies have to worry about, think again. Every team member, every policy, every training session, it matters. So now is not the time to scale back. If anything, it's time to level up your compliance strategy. We know you'll do that. So thanks for joining us on Case Files. Until next time, stay aware, stay compliant, and keep leading with integrity. Take care, everyone.